Hi, I'm Jeremy Blackowicz. I'm Senior Counsel at Pitney. I practice in the Trademark, Copyright, and Advertising Group. I'm coming up on over 18 years in practice. I have a background in litigation and right now predominantly focus on portfolio management and strategic IP enforcement. We work with clients to help them identify their trademarks, copyright, and intellectual property assets and learn how to turn those into business opportunities, investments, and also how to strongly enforce those marks and protect them against encroachment.
My name is Ryan Osterweil. I'm a senior associate at Pitney. I've been at the firm for about 6.5 years, and I spent about 3 years at a firm before that. I split my time between the trademark, copyright, and advertising practice and the patent practice at the firm. I am a registered patent attorney, so I cover a variety of interests within the IP field. Being strategic about your IP portfolio is important at all times, but even more so when budgets are tight and you're trying to reassess priorities. It is important on both the trademark and the patent front to make sure that you don't lose ground, miss deadlines, as Jeremy mentioned, but for different reasons. So on the patent side, there are actually statutory bars that will prevent protection of inventions if you have publicly disclosed your invention more than a year before you file. Now that's a little bit detailed, it's a little bit nuanced as to what exactly that means, but as a general guideline, we recommend to clients that anytime you are going to make a press release or seek assistance from a manufacturer or launch a product line that may go out to new customers, getting a patent application on file before that happens will ensure that nobody beats you to the punch. So the US and most countries around the world fall under what's called a first to file patent system, which means that the first person to file an application to protect an invention is deemed the rightful owner. So if you do not file before you make a public launch, there's a possibility that somebody else could actually swoop in and try to beat you to the punch. And obviously there are ways to prevent them from ever getting rights to something that you invented, but in the process, it may actually prevent you, the rightful owner, from having those rights. And as a second point, if you postpone too long after you make such a disclosure or launch a new product, the law may actually prevent you from seeking protection down the line because the invention is then deemed in the public domain.
For trademarks, part of your strategic assessment does not always mean that you have to spend more money. What you may find when you take a close look at what you actually own and what you're protecting is that some of that may no longer need to be registered. You may not need to incur additional costs, and you may find that you can shift or free up budget to new projects. So for trademarks, when you're looking at new filings, you need to understand that in the United States, you have to prove use in order to register. Around the rest of the world, you do not need to, so it's a first to file system, meaning the first person to run to the trademark office and file their papers gets those rights. So that's why it's important that we never allow IP matters to fall too far behind, because you may find that your rights have been foreclosed. But when you take a strategic assessment of your portfolio, this is where you can find those opportunities, and you may be able to find budget that you didn't realize was there in order to accomplish those goals.
When protecting your inventions and seeking patent protection, there are ways to be cost saving upfront and postpone fees until later. One and the easiest way is that there is a mechanism called a provisional patent application, which is essentially a placeholder that gets filed with the patent office that does not ever get examined, but is simply there to allow you to claim your stake in the sand and make sure that you have a priority date before you launch or make your invention publicly known. So there are no real rules as to a provisional application, given that it doesn't have to meet any requirements for examination. So what can be done is a very bare bones outline of your invention, which then gets filed with little formality, but just to make sure that the 30,000-foot view of your invention is there in case anyone ever challenged it. That will give you 1 year within which to seek full-fledged patent rights here in the US and abroad, which will give 9 to 10 months before you have to make some difficult decisions and really invest funds in drafting a full-fledged patent application, which hopefully is long after the global climate has changed. On the trademark side, similarly, there are ways to postpone fees by using different tools at our disposal. One being that when you file a US trademark application, you have 6 months within which to file internationally. And oftentimes, you may be inclined to pursue international protection as quickly as possible to try to get registration before your business expands. But you do have that 6-month window before having to pursue rights internationally so that you can defer costs.